Hello everyone, we are starting the next session which is on the key regulatory issues in the India. There are many regulatory issues and I welcome, there are three expert panelists in this session. I welcome Dr. Rakesh Maheshwari, Kirti Trihan and Vivan Sharan. Please. Dr. Rakesh Maheshwari is a tech policy and regulatory compliance, former senior director, group coordinator, cyber laws and cyber governance, Ministry of Electronics and IT. Rakesh is an expert on cyber law, the DPDP Act, online safety, advisory, tech policy firms, law firm, NCPCR, and think tanks in India, including DSCI, Cyber Security Association of India. He is a former government officer, having worked more than 35 years. During his tenure in the ministry, he handled activities related to the IT Act, Personal Data Protection Bill, regulation of online intermediaries, including social media regulation, regulation of online gaming, cyber security policies, Aadhaar related issues, various capacities including a senior director and group coordinator. And he handled CERTIN and UIDI, instrumental in development of the IT, intermediate guidelines and digital media ethics code. He worked for online safety, particularly for women and children safety, instrumental to the launch of National Cyber Crime Portal, cybercrime.gov.in, MOU with NCMEC, USA, and coordination with MHA, CBI, etc. Have handled 400 court cases at all levels, representing government interests, including about 50 cases in Supreme Court and 300 cases in various high courts across India. Guest faculty for eminent organizations like LBSNA, Missouri, India Policy Academy, Police Academy Hyderabad, IIPA Delhi, Judicial Academy, Indian Law Institute, and other law enforcement agencies. He is an engineer and from the Delhi College of Engineering and Law from the Cyber Law Diploma. Kirti Trihan, our next panelist, is the Data and Co-Law and Policy Advisors, ex-Netflix, Amazon, Business Focused Product Council, and Regulatory Public Policy Advisor with 10 plus years of experience with payments, entertainment, e-commerce, gaming, and telecom companies across privacy, data security, online payments, content sensitivities, online safety, safe harbor, consumer protection, competition, antitrust, and manufacturing, expert in the crafting policy and advocacy strategies on global payments and privacy regulation. Certified privacy practitioner, Master of Laws from the London School of Economics, public speaker and writer, passionate about rescuing dogs, slow travels, and next speaker, Vivan Sharan, is a partner, Quan Advisory Group, is a partner in technology policy, consulting firm bases in Delhi. He works on the political economy of the technology markets and advises Fortune 500 companies, international organizations and governments. Vivan works on diverse public interest issues. He is on board of the ISIA Center, an innovation policy think tank in New Delhi, and is an advisor to Sitara, India's first science, indigenous technology and advanced research accelerator. He is also a co-founder and board member of Civikalpa Sciences, R&D based. So Vivan Sharan is a partner. No, this is okay. So he is passed out from the Stephens and Delhi Economic School. And you can, as you have seen, the three panelists are very, very knowledgeable and well experienced in the issues of the. Today I will be taking three kinds of law issues like DPDP, the data product, the gaming, and AI laws. Is it okay, panel? Or anything else? That will be enough? Yeah. So, as you know, at the previous session, the digital economy was there, and where you heard many issues on the digital side. We have 965 million internet users and reach 1 billion next year. The IT sector contributes significantly to India's GDP. Startup ecosystem is there, digital transformations are there. Global hub of ITS services, IT sector, digital transformation. Key regulatory frameworks are in place. Importance of regulation, we will emphasize how the regulations are essential for innovation, consumer protection, and ethical practices in IT. So I will begin my discussions for the next 90 minutes, this place. So I will ask first Dr. Rakesh Maheshwari to say his initial remarks, 5 minutes, about the overarching theme of this.
Yeah, so once again, a very good morning to all of you. The theme of this particular session is about the key regulatory issues being discussed in India. And therefore, in the digital world, that's what my interpretation is as to, in the digital world, as to what are the key regulations which either exist or are being discussed are being developed. And to that extent, as I mentioned in the previous session, it's the Information Technology Act, which is a lateral act and governs the cyber space as of today in India. So not that it is the only law, but it is one law which takes care of the whole. And then there are in between sectoral laws, sectoral regulators, which define the specific nuances, including the online aspects for that particular sector. I did discuss about the length and breadth of what cyber law does cover. For last 1.5 years, specifically, that the government of India has also been talking about a comprehensive amendment of this particular law. Sometimes it's called as the Information Technology Amendment Bill, which is what the government shall introduce. Other times, it is also being talked as the Digital India Act or Digital India Bill, which will hopefully be taking care of the present day nuances, complexities of the digital world in the context the present IT Act covers. Particularly after the privacy having been declared as a fundamental right, that it is being felt that it's not just about with respect to the privacy, but with respect to the other aspects that the users need to have the digital rights defined. It's also becoming very clear that the way intermediary liabilities were defined in the IT Act, actually IT Act talked about exemptions subject to certain due diligence. And beyond that, so the aim was in fact promotional activities. The aim was to see that the intermediary ecosystem in a way innovates itself. But now that the intermediary ecosystem has graduated, has grown, large number of and large varieties of intermediaries do exist. Once again, and then small ones, large ones, and very large ones. To the extent that they determine who is the boss, they determine the competition, they control the competition in many scenarios. So this is one area which therefore needs to be looked into much more in detail. In between, Honorable Minister of State, Mr. Rajiv Chandrasekhar ji, at that time had said that maybe the safe harbor provisions shall be re-looked into. So, I mean, this is something which actually sent jitters to the industry as to if the safe harbor provisions are withdrawn, maybe when, to what an extent, and how much will it impact. So all those aspects are the ones which are being discussed. So one, the Digital India Bill or Digital India Act, whichever way, but then of course technically it is bill. The two, ex-ante Digital Competition Bill 2023 was presented for public comments by Ministry of Corporate Affairs, which is therefore under discussion as of today by Government of India. Certain principles have been laid down, certain criteria of who shall be considered as significant, something similar to what we say is the DSA and DMA approach of the Europe, if you are familiar with the European digital laws. There are few more things which are happening. DPDP Act, we have already talked about, we shall be talking about. Online gaming regulations were also introduced prima facie through the IT rules of 2021 with its amendment as carried out on 6th of April 2023. However, the amendment which was carried out with respect to maybe allowing and due diligence as was created for such permissible online games has actually not been implemented, and which is therefore one more area which once again needs to be relooked into. Either you continue with the existing rule which has been defined in 2023, or maybe relook as to how exactly should they be regulated. Maybe should they not just be, should we regulate? If we need to regulate, how do we regulate? Why this becomes important? Particularly because online, in fact, the subject of betting and gambling by Constitution of India belongs to the state. So there is a state and center overlap. So this is yet another area. In 2023, and I'm taking a bit more time, but then I'm trying to cover the landscape of what are the issues as of today in the digital world. So there was a broadcasting act. A new broadcasting act was also proposed by Ministry of Information and Broadcasting in 2023, which wanted to cover all the existing broadcasting acts being put together like the Telecom Act, that all the acts be brought together and including the regulation of the online over-the-top platforms, OTT platforms, so online news platforms. So those are the things. So about TV, about print, about online digital medium related to the scope of MIB, including advertisements, is what was addressed there. Then, of course, the Telecom Act of 2023, for which rules have started rolling out. So rules are once again presently under discussion. Few of them will come. The regulation of AI, which is also being talked about. Lots of things have happened internationally. Should India also maybe develop its own law, is something which is let's say, or which is a matter of debate, which is a matter under consideration. So is with respect to the regulation of cryptos, the virtual assets. Cyber security is yet another area, though covered in the IT Act. Should it continue to be covered under the IT Act or through the Digital India Act, or should we have a dedicated cyber security law in the country? E-commerce rules were also, a draft was also published somewhere in 2021, 2022. Maybe Vivan will be able to, madam will be able to tell more. But then this is yet another area which is being debated as to what should be the way out. Very recently, the Ministry of Consumer Affairs came up with the guidelines for the dark patterns. So those are also the things which are also relating to the online gaming. And lastly, about the online advertisements, as to how should they be regulated. So I am only trying to cover, in a way, I have just taken the name of what are the various issues. Very recently, fact check unit order has been, something initiated by the government has been struck down by the Mumbai High Court. So that's also an issue. And lastly, before I close, tobacco advertisements are once again into limelight as to how on the OTT platforms the tobacco advertisements should be given. Ministry of Health and Family Welfare has once again given certain draft rules which are presently under discussion. Yeah.
Thank you, Dr. Maheshwari, and it was a very vivid picture of the whole spectrum of the laws which has been, emerged last couple of years, whether it is in the fact check, which is very recent, AI, and other regulatory issues, cyber security, IT Act, which is earlier was there, and the DPDP Act. So this gives you a picture of how all these acts. Now I will request Kriti to come on initial remarks on this.
Thank you. And thank you, Dr. Maheshwari. I think that was very helpful context setting. Maybe I'll try and focus on the three areas that Dr. Govind, you mentioned we want to talk about today, which is on privacy, on AI, and on gaming. Privacy as a topic, of course, we've already kicked off in the previous session. But we've come a really long way from the original Puttaswamy judgment in the Supreme Court in 2017 to Justice Sri Krishna's white paper, to Justice Sri Krishna's bill, to the discussion in Parliament, to the JPC review process, to multiple iterations of the privacy bill itself, finally to the law that got enacted last year. And it's been an interesting process, and we spoke a little bit about how the law, of course, is a step in the right direction, the fact that it's principle based and not overly prescriptive. I think one of the key challenges within on a principle level in the Data Protection Act is around delegation of creation of rules, and I think that the fact that certain concepts and certain principles are being delegated is going to be a bit of a conversation in this space over the next couple of months, for as long as the rules are sort of still in the process of being created. Some examples of those issues, I think someone talked about a consent manager earlier on in the previous session. You've hit the nail on the head that on the consent manager piece, there are a lot of open questions. How would it come into force? What does a consent manager really mean? These questions have still been left to delegated legislation, and so that's definitely going to be an open conversation. Data breach notifications, like we also discussed, is another part of it. Cross-border data transfers is another key issue. The pro is that cross-border data transfers, the discourse on it has gone through multiple layers of discussion over the last 6 odd years, from a very restrictive regime to a very open regime, and I think we're in a good place at this point in time. As you'll know, the act itself talks about a negative list to be populated by the government, which is a list of countries where companies cannot transfer data without permission. And so I think it's a good place that we're in at this point in time. But what will happen? Will that list? How will that list get populated? What is the appellate process associated with that list? How do we think about business impact for companies who actually transfer data to said countries which are on that list? Is it a permanent list, or will it get repopulated from time to time? These are all questions that continue to stay open-ended and tend to keep folks up at night every now and then. And then, of course, is the challenge around global practices versus the Data Protection Act in India. For the large part, principles in global norms like the GDPR are echoed in the DPDP Act as well, but there are some distinctions. First and foremost, of course, is different categories of data. And this is a deviation from existing Indian law as well. Existing Indian law, like we discussed, talked about two categories of personal information, which is personal information and sensitive personal information. There are similar categories under the GDPR and under global legislation as well. The Indian law now treats all personal data as equal. Is all personal data equal is a bit of a question mark, and I'd encourage all of you to think about it. And therefore, applying the same threshold to all categories of personal data, is that the best way forward is a concern. The second thing is the Indian law talks about personal data in digital format only, not in other forms. I'm sure many of you go to different apartment buildings and the gentleman at the gate will make you sign in a register with your phone number, potentially where you've come from, who you're meeting, so on and so forth. Those kinds of storage of personal data not covered within the Data Protection Act. The third thing is publicly available personal data. Publicly available personal data finds protection in international norms, particularly in the GDPR, does not find protection under Indian law. I'm not saying that necessarily a bad thing, but it's a thing. It's just something to be mindful of as we go into enforcement of this law eventually. And then the final thing is the grounds of processing personal data. Largely echoing the GDPR consent, which includes contractual requirements, kind of gets covered within the DPDP-A, but legitimate interest as a reasonable ground of processing data is not included within the Data Protection Act. So I think there is a lot of conversation that is yet to be had on the Data Protection Act, and you can expect these discussions to kind of take the fore over the next few months for sure. But generally a step in the right direction, definitely. I'll move on to AI quickly. AI, as Dr. Maheshwari said, is a topic that has been within regulatory conversation for a while now. But really, what are the key issues on AI? If we just zoom out of India right now, what are the key issues with AI insofar as regulation or policy is concerned? I think it can be divided into 5 broad issues. Number 1 is transparency. What automated decisions are being made about me? In what manner is my data being used? How are the models being trained using my data? All of these are questions that are open-ended around transparency right now, and this forms the cornerstone of the EU AI legislation at this point in time, which is to build a transparency-first regime. The second challenge is around intellectual property rights, so copyright-related issues, principally talked of within the context of generative AI, likenesses, whose rights vest in said likenesses. If I never stood for a photograph and somebody used an existing photograph of mine and used generative AI to convert that into a different format with me wearing different clothes, who's got the AI in it? Do I still retain the right to those photographs for myself, or is the company that has created that generated picture hold the rights in it? The third challenge beyond transparency and intellectual property rights pertains to labor, the future of the workforce. Of course, with AI, with the onset of AI, there's going to be new jobs that will get created for the workforce in India. But there will be certain jobs that will perhaps get done differently or in a more cost-effective manner by AI. So how do we make sure that we balance, of course, innovation along with the rights of the workforce and think about the future of the workforce? The fourth one is privacy, self-explanatory. what data of mine is an AI LLM using? How are they using that data? How are they storing it? Who are they sharing it with? In what format are they sharing it with third parties? If it becomes publicly available as a result of said sharing, what rights do I have to that data? All of those questions remain open-ended at this point. And the last one is around accuracy and misinformation. Deepfakes, of course, has been a really big conversation in India, particularly, and overseas as well, particularly in electoral contexts. We've had a lot of conversation on the subject. And so, generally speaking, what is the responsibility of artificial intelligence companies in maintaining the accuracy of information that they're putting out there? AI, as we all know, has struggles with hallucinations at this point in time. How do we make sure, is hallucinations a product problem or is it a product growth problem? Said in another way, is it a teething issue at this point in time, or is it something that is inherently by design a concern within the product itself? So these are the 5 broad issues from a policy standpoint that I think any and every conversation on AI can broadly get bucketed in. And of course, I'm sure Vivan has a lot of thoughts on that as well. But between transparency, IPR, labor, privacy, and accuracy or misinformation, those are the broad verticals within which I think a lot of the AI conversation falls. And then finally, there's the gaming discourse. Did you know, I didn't, but did you know that the Indian gaming industry at this point is valued at roughly about $3.1 billion? With 442 million gamers in India at this point in time, we're only second after China. I had no idea those were the numbers. So clearly gaming is a massive opportunity for the country, and it's been recognized as such by the government as well. The government, through the AVGC XR policy of 28-29 is talking about how to foster competitiveness in the gaming ecosystem, just building games, building IP that is India-focused IP, innovating in the gaming sector, and of course creating a conducive overarching policy environment, which is really why the conversation on gaming has gone into the self-regulation domain. And like Dr. Maheshwari mentioned, the 21 rules that were amended in 23 from a gaming standpoint do exactly that. That is not to say that there are no challenges within the gaming sector from a policy standpoint. I think one key issue, and Dr. Maheshwari touched on it briefly, is the big concern on gaming really has been definitional challenges. Now, to think about this historical context is really important. As a subject, gaming is not covered in regulation as such. Gambling, however, is. And gambling is a state subject, which means the state governments can make legislation, are empowered to make legislation on gambling. And in most parts of the country, not all, gambling is declared as illegal. Why is this relevant? It's because the combination of gambling with gaming has gotten conflated over the years. And so a lot of times you've had courts that have had to weigh in on what game is gambling and what game is not. Hence the oft-repeated question of game of skill versus game of chance. And I think it's a missed opportunity that the rules don't really talk about, the central rules don't really talk about game of skill versus game of chance. Arguably they can't, because a rule is delegated legislation. It can't go beyond the scope of its parent law. But it is a missed opportunity that we don't have legislation around game of skill and game of chance. The second challenge, of course, related to this is regulatory ambiguity that comes from the fact that regulation can be made at the central level as well as at the state level. So how do we make sure that everybody is talking to each other and everybody is on the same page so as to create predictability within the gaming ecosystem, of course, is important. And then finally, of course, kids' safety comes to the fore when we talk about gaming, whether it's behavioral aspects of gaming or it is around parental controls associated with gaming. I think that's a great opportunity within the regulatory space as well. From businesses' standpoint themselves, I know fraud and money laundering is top of mind, particularly for real money gaming. And, how do they kind of solve for that? And as a ease of doing business question, I know the GST of 28% has been, again, top of mind for a lot of gaming companies. So generally, this, to my mind, is where the gaming ecosystem stands. And I'm going to stop here.
Thank you, Kripi. Now you heard the two panelists on the tech policies and the AI, gaming, and the data protection. So even I would ask you the how to initial remarks on the domestic political economy. How is it impacting these tech policies?
Thank you. I can hear my voice echo, but I hope it's all right in that room. Okay. The co-panelists have covered a lot of ground, so I think I'll just go in reverse order from what Kriti had said to what Dr. Maheshwari had said and place it in the political economy context as you've asked me to. So, intermediaries, I think it would be easy if we were able to think of the word in binary, so I'm going to paint it as a binary. It's not always a binary, but maybe it simplifies understanding to some degree. I see the debate on intermediary regulation as one where there are contestations between small and large intermediaries and Indian and foreign or offshore intermediaries. Now, small and large plays out in what Kriti said, in safety, various other trust and safety issues broadly defined, which encompass a whole lot of user safety issues that I'm sure you've been covering in different modules. But the question for India and for all of us is, do we create a differential standard for trust and safety of kids, women, vulnerable populations between small and large platforms? And if so, what is the logic of doing so? Is it fit to purpose with the way our constitutional framework is? Do people enjoy different rights on different platforms? Do people are different platforms or services or intermediaries just by virtue of being smaller or larger completely distinct classes? So those are things to think about. Indian versus foreign, and foreign I mean offshore. So those who are registered and have an office in India are very different from those who are not registered and don't have an office in India, for the reason that if you're not registered and don't have an office in India, then people like Mr. Maheshwari will find it very difficult to enforce rules under the prescribed due diligences on you. And the internet is global. We are not following the Chinese firewall model, and therefore enforcement of due diligences on intermediaries can be differential between those that are onshore and those that are offshore. That creates a bit of a regulatory asymmetry, perhaps a scope for regulatory arbitrage. This is not a question that India alone can answer, but it's something we have to grapple with going forward. Now, coming to data protection, again, I think Kriti touched on a very important trend, which is subordinate legislation. We're going to see that across different spaces. Mr. Maheshwari talked about the broadcast bill, for instance, that has over 60 rule-making provisions. So there are 60 areas where you don't know what is going to come. So data protection, the issue really is whether the notion of trust based on how different political systems view each other in the world is going to dominate the way in which data flows from one jurisdiction to another. And whether you look at it from the point of view of what India is doing, which is basically to create a negative list of countries where data shall not flow automatically without permission, personal data in particular, or you look at what the Europeans have done, which is in a sense it's similar. It doesn't create a negative list, but it creates obligations that are of a level where unless you are complying with those and you are deemed to be adequately complying with those at another jurisdiction, there is no automatic allowance on transfer of sensitive data, whatever you may define it as. And there are various other regimes that are developing in between these two extremes of either taking a negative list approach, which India has taken, or the European level of compliance, which is applicable to all. And at the end of the day, the Europeans have a lot of political room to maneuver, or they exercise a lot of political subjectivity when they deem a jurisdiction to be adequate in terms of following the levels of compliance that they wish for jurisdictions to follow. And there's a lot of interesting jurisprudence around this, which I won't go into, but many of you would be aware of the Schrems cases that have led to the falling down of the so-called privacy shield between Europe and America, even though the two are traditionally allied in many spheres. So this is an evolving debate, and in the middle there's also, of course, commercial agreements, plurilateral agreements, through which greater trust can be built between businesses, between institutions, and it is going to be both a multipolar or a sort of multipolar and a multilateral way as things proceed. I think Priti maybe touched on the worker protections. This is again, if I frame it as a binary, it's sort of a evolution of how we look at unions in the country, trade unions. We have the question really is, do informal workers who are associated with the digital sphere or unorganized workers, do they somehow, because just the service is digital, enjoy a different set of rights than those who are, associated with non-digital enterprises and are similarly unorganized? And I think the answer to this is not simple, but it's certainly an interesting question that states are debating more and more. You see the worker protection legislation crop up in various places. It's not obvious to me that the answer is an affirmative, that somehow digital services exercise more control than your average contractor on the workers that they contract informally, and therefore there should be some differential rights regime or obligation on the contractor, whoever he or she may be. So this is another interesting area. Consumer protection, I think, as a binary, it's one between online and offline parity. So do we talk about things like dark patterns, which were mentioned right now, or let's stick to dark patterns. There are some 12, 13 dark patterns that are being described as akin to misleading advertising and unfair trade practices by the Consumer Protection Authority, and or the Consumer Protection Authority has the right to adjudicate based on those notified patterns. The point is, do we look for these patterns in the offline world? Are they on people and so on? When you go to a store and you're buying something at the eye level, maybe there is a different deal that the store owner has struck with the distributor than something which is not at the eye level when you're purchasing. And so are these also dark patterns? Are we going to start regulating all retail trade similarly? Or do we want to just pick out online services because they're easy to pick on, so to speak? That's another area that will evolve. Content regulation, Mr. Mahesh touched on. I see it as a debate between the legacy and the new. So the legacy players from television distribution, for instance, have been asking for similar controls on digital distribution, even though the technologies are vastly dissimilar. Just to illustrate, when you watch TV, the signals are already there, either in the airwaves or in your cable. You switch on your TV, you select the channel. For those of you who are old enough, you had those TVs with the button. When you click a button, the channel will be streaming. Not because it wasn't, the button did in effect lead to the streaming of the channel. It just allowed you to access something that was already streaming, as opposed to digital streaming services like the one that we used to work for, Netflix. When you go to a website and you sign in and you open a particular stream, then you have to pull that information to you. It's not the case that Netflix is streaming its 1 million titles altogether online, because that would lead to immediate bankruptcy given the cloud costs that everyone incurs today. So it's a completely different model. And so the question is, and there are also arguments around private and public viewing that we can employ to and others that differentiate at a functional level the old and the new. So the question is to be able to protect the old business models, do we regulate upwards or regulate downwards? Which is, do we allow TV broadcasters to be
We can
freer,
go to the
or
next
do
one.
we disallow?
We can go to the next one.
Et cetera, to be more,
Okay.
I mean, disallow them from being not regulated similarly to TV and therefore impose more controls on them. And finally, an aspect that we haven't touched on, and then several others, is public procurement, which is also a big political economy issue in technology. I think we're seeing, on the one hand, there's public procurement, on the other, there is incentives for growth of certain critical industries, as you know, semiconductors, smartphones, etc., where we're trying to build sovereign capability without losing to those dominating the field because technology changes quickly and supply chains also have to keep up. There are nuanced debates in both, but suffice to say, I think the political economy around those who are trying to ensure that there's a level of protection for the domestic market versus those who are trying to tap into the global value chains. There's a healthy tension. Sometimes it plays out in the context of the public procurement rules being tighter than they ought to be. So we have, for instance, domestic value addition requirements for even software, which is a very unheard of construct in many places in the world, because it's very hard to say which software and how much percentage Indian innovation and Indian effort and so on and so forth versus saying the same for hardware. But we do that because there is a impetus to try to protect some of the domestic software ecosystem. And at the same time, on the incentive sphere, we are encouraging local companies to come here and to co-locate their suppliers here and to integrate across the global value chain. So there's this duality even here, which plays out in interesting ways. There are many other areas of tech policy. You can go on and on. Antitrust is another big one, and I hope we can touch on. AI is already been touched on. Thank you. We can take it up in
Yeah. Thanks everyone, and now I go to the specific questions, one or two from the each of the regulatory issues quickly, so that then we open to the audience. So, Dr. Rakesh Maheshwari, how to obtain a meaningful, consent for the users when a partially worded notices are there in the platforms, so that users are not very comfortable to say yes or no kind of thing for the consent.
Yeah, so I can only talk about what the law says. The law as of today, so DPDP Act as of today says that the consent has to be legally allowed, and that has been further conveyed that something which has not been illegally, not legally impermitted is what can be called as permitted. The consent has to be informed consent. Consent has to be fair, and consent must also convey the purpose. Consent has to be granular, and in the default mode it is no. So in a way, the contractual agreement that happens between the platform, the app, the website versus the user, the data fiduciary, is actually happening through this consent management, which as of today probably happens that many of the consents are assumed to be deemed consent, and a long statement finally resulting into yes, I agree, and there is practically no option for you not to agree if you want to continue to avail services of that particular app, the website, the platform. And to that an extent, the DPDP Act will provide the granularity, the purpose, and shall actually, certain consents will automatically become invalid or maybe not allowed because they are not permitted in the specific context covered by the specific law in which it is not really allowed you to collect certain data. So in my view, this is the beginning of what we are saying, a comprehensive privacy enabled kind of a mechanism in the digital world.
You take a short, or should I tell you another question?
No, if you want, I can add to this.
Yeah.
I think there's two ways to take consent, right? One part of it is sparsely worded documents, which are not enough information. The other part of it is incredibly detailed documents that can potentially lead to consent fatigue. I mean, how many of us actually scroll down till the end of everything, even today, even in heavily regulated regimes? So there is no silver bullet, I think, to what constitutes as true informed consent. I think the law's done a really good job of talking about specificity, clarity, fairness, everything that Dr. Maheshwari talked about. The one incremental thing that I would add, perhaps as a user of services rather than anything else, is not all users are equal, in that not all users are actually going to be able to read, comprehend, and understand every aspect of a notice. And so folks should ideally go above and beyond and expand their consumer education initiatives and extend that to the consent procurement mechanism as well.
It also mentioned that the consent should be withdrawable, and the ease of withdrawing should be as comfortable or as convenient as was the ease of giving the consent. To that an extent, that process, including the contact details of the person to whom you need to approach to be able to give a request for withdrawal, and at any given time you want to change, amend, or maybe update your details, all those things will now be possible. And hopefully with the rules coming in place, probably the consent which has been given, a copy of which can always be referred by you, so that you know what was actually given. So those things are going to happen.
Thank you. Your quick comment, Vivian, on this?
No, look, you have two data protection experts there. I'll just say something contrarian here, not related to our act. I think the future of data protection is extremely bleak. We have devices that are constantly recording everything around us. We don't take people's consent when we are making all the videos that we make during the course of a day. We don't take their consent when we put CCTVs on, outside our homes. And, you can extrapolate from here. We also, I think, if you draw a strange analogy, and permit me, because this is a classroom, we should experiment with our thoughts. We don't, the food manufacturers don't necessarily take our consent before mixing harmful ingredients in, say, ketchup. It is up to us to read the ingredients of that ketchup bottle to understand that actually ketchup is not all tomatoes and all nutrition. It's also a lot of sugar that maybe exceeds our daily dose. So I think the future of privacy and the future of data protection will lie in some extent to how quickly the world can pivot from this informed consent model, which derives from medicine, which is a very different controlled environment where you go to a doctor or practitioner and ask for consent. I mean, the doctor has to ask for consent before something invasive or something that is going to potentially harm you, etc., etc. That's a very different controlled environment for a free-for-all, which is akin to the fast-moving consumer goods market where you can go and buy anything off the store, and everyone has people are selling you things all the time on the streets, and so on and so forth. I think signaling the equivalent of nutritional labels in the world of privacy is going to be the future. You should know when you're using an app how private it is, how secure it is by design. To some extent, app stores have begun to do some of this duty, but obviously we also download a lot of apps or engage in a lot of online activity outside of app stores. So I think we'll have to find a mix between signaling and existing models, and some of borrow from areas like energy ratings, food ratings, etc. to do so. Sorry for throwing a spanner in the works, but just a thought that I wanted to share with you.
Thank you, Vivan. I will quickly jump to the next regulatory issue of AI. How can AI models be prevented from giving defamatory outputs on both the mod? No, not to Vivan. Vivan se pucho, acha. Okay. So Vivan, here is the question for you. How the AI models be prevented from giving a defamatory outputs, and can they be liable for that, hold responsible for that?
That's a very complex question. I think it will take hours to unpack that because liability will stem from multiple things, including whether the model that you are using is open model, which is that somebody has deployed something like a Llama model, some derivative of Meta's open AI for generative AI, or whether it is a proprietary model where there is private ownership and control to some degree of the design of that model. There is also going to be differentiation between the liability of the developer and the deployer. So, are you talking about the liability of a tech company that has developed a model, or the developers who have used an open source model to develop a model to the extent that can be used? Or are you talking about a deployer? So, for instance, if I am a university like yours, and I'm using a chatbot to interface with prospective students who are applying to me for admissions. In that case, is the university liable if I'm turning away students on false grounds, or is the developer liable? And if there is an open source model, how is the developer liable? And to some extent, I think some of these complicated questions will play out first in more sensitive areas, more critical areas. So healthcare is an example. I don't think we can afford to be very wishy-washy about liability in the area of, say, medical diagnostics. There is sufficient clarity in my mind that the deployer, which is the hospital or the diagnostic center, has to be enlightened enough to know of the risks posed by a model before deploying it in the real world, and has to inform users or consumers or the beneficiaries of these diagnostics of the kind of risks that are posed through automation of some of the diagnostics. So what are the chances of errors, etc. Just like a doctor already does in the case of many diagnostics. You are always given a margin of error. So to the extent that you're informed, that liability should lie in my mind with the medical practitioner or the diagnostic person. We have a set of guidelines by the ICMR. I encourage you guys to read it on this question. And for you to find out the answer, whether it fits what I'm saying, they've taken a different approach. It's an open question for you guys to do some homework. But suffice to say that in these sensitive areas, and another is finance. Before you give financial advice or before you receive financial advice from a financial broker that is using generative AI, are you sufficiently informed of the kind of things that go wrong in such models and the liabilities associated with all of this? Will evolve first. It's not a straight answer that can answer from all contexts. And you have to separate between developer and deployer responsibilities and accountabilities as you go forward.
Thank you, Vivan. for giving an elaborate answer to the question. My third question is going to be on the gaming. How the gaming rules are going to affect the smaller players, and whether how the gaming rules will know the game of chance or game of skills, how they are going to distinguish between the two when any laws are, whether sufficient adequate provisions are kept in the law to distinguish between the two kinds of thing, or is it in a different way?
So in the IT rules amendment of 2023, the regulation of online gaming has been addressed to the extent it could have been within the context of or within the limitations of the existing IT Act 2000. As I mentioned, the subject of betting and gambling by constitution belongs to and is regulated by the states. If therefore the subject of gaming had to be taken through the rules, a beautiful word was carved out, which was one, of course, the definition of online gaming. The other was permissible online gaming. And which is where it has been conveyed that a game, an online gaming in which there is no wagering or betting on, no wagering, betting word has still been avoided. No wagering on the outcome of the game is what shall be considered as the permissible game. Now, having said this, an attempt was made by the central government to differentiate between the gambling and betting versus the legally allowed online gaming. Further, of course, the rules do define the concept of SRB, the self-regulating bodies, and it has been left. I mean, the rules have actually given the constitution of self-regulating bodies, including who the people should be, to ensure that one, it is widely represented, two, that it is completely independent of the associations and of the companies, and three, for them to take up the call whether it falls within the definition of permissible or not. Now, whether the liabilities should be proportionate, whether the differentiation between a smaller player and a larger operator should be done, is what has been left for the SRBs to decide. And ideally, it's not that the SRBs only would have been there. In any case, I mean, they have not really come up as yet. But had the SRBs been approved, I am sure as the things evolve, along with the government, these SRBs, 3 of them, 4 of them, depending upon how many would have been approved, could have resolved this issue of keeping the proportionality into the mind and ensure that the due diligence guidelines, including certain additional due diligence guidelines, which is about having the grievance officer in place, the other few officers also in place, transparency reports being there. The whole concept of responsible gaming within the permissible gaming is brought in. So that's how it was envisaged, and something which is not permissible for them, not only the gaming formats, those gaming formats become illegal, the advertisements for them also become unlawful, and therefore it was expected that the social media platforms on which such ads normally do come up, or maybe any other sites on which such ads may come up, then there is a mechanism to differentiate between what is considered as allowed versus not allowed, lawful versus unlawful, and therefore to be able to take action. So that was the scheme of things designed, and as I said, there was a serious limitation within the IT Act which deals with only intermediary due diligence, whether these gaming operators who actually decide and who are actually aware of the gaming format, should they at the first place, should they themselves be called as the intermediaries or not, was a larger question, but that is what we left it to the courts to take the call. The intent was right.
Thank you, Dr. Rakesh. Kriti, you could comment on this?
No worries. I'll just add a couple of points on this. I think the intent of the rules, of course, is helpful, and it provides direction in an otherwise complex and unclear environment. So to that extent, I think the rules have done a really good job of setting the stage. I think there's still room for some more work to be done within that. One example of it, and this is why I think there is a disproportionate impact on potentially smaller players over perhaps larger companies that foray into gaming. One part of the job that the SRBs were expected to do was, like Mr. Maheshwari said, they're supposed to determine what are permissible games and what are the do's and the don'ts. And as a part of that, companies are expected to kind of provide their games and the details of their games to the SRBs, who will then determine does this fall within the permissible game mandate or not. The challenge with that really is, in the absence of the SRBs having done so all this while, there's a vacuum that has essentially gotten created. As a result of which, we see certain state governments, particularly, if I'm not mistaken, Tamil Nadu and Karnataka, that have started talking about what are permissible games and what are not. Now, if we zoom out a little bit, and we'll go back to the original point that I was making, which is regulatory ambiguity when you have many players involved adjudicating upon the same issue. The fact that there is a central set of rules, but there are also state governments foraying into the topic with perhaps a different approach and a different opinion on what is permissible, what is not, it creates a lot of regulatory ambiguity, and regulatory ambiguity will almost always impact smaller players disproportionately. The other thing is, while the rules talk about a self-regulatory regime, the fact that there is a grievance officer that needs to be appointed, that there's local documentation that needs to be provided. These are all compliance heavy processes. Not to say they're right or wrong, but the fact that there are all these compliance processes associated with gaming, again, smaller businesses are likely to feel the impact more than perhaps larger businesses who potentially already have certain processes and procedures in place, internal mechanisms that they can eventually leverage. So I do think there is a bit of a disproportionate impact, much like with most new legislation, for smaller businesses. And I think the SRBs working thoughtfully across all these different topics could be really helpful at this point, particularly for smaller businesses.
Thank you, Krithi. Vivan, your quick comment on this?
Yeah, in addition to what has been mentioned, there are 2-3 other perspectives you may like to consider in this room. One is that if you're an Indian, you're sitting in Tamil Nadu, you're sitting in Assam, you're sitting in New Delhi, do you have a right to information across the country in a standardized internet environment or not? And this is the reason why telegraphs, telephones, etc., which requires a set of standards to be interoperable and to be scaling at a national level, of putting the list of issues governed by the center under Schedule 7 of the Constitution. So that's an open question for you guys in the forum. Different people may have different answers. You may believe that some states are exceptional and they don't indeed deserve the same information environment, data environment, applications environment as another part of the country. Maybe some areas are sensitive, so they are blocked, and we know we have a lot of internet shutdown. So that's also part and parcel of this larger debate, I would say. The other is, what are the states that are banning certain forms of online gaming despite years of jurisprudence, etc.? What are they achieving with this? And I think that is the question is not easily understood just through the realm of tech policy. You have to understand, for instance, what what betting and gambling offline looks like. Are Satta markets in Tamil Nadu flourishing as they used to earlier, or is there some sea change just because there's increased enforcement or something online? And the answer is obviously obvious that the offline arms are not abating. In fact, maybe there is more disposable income towards some of these activities. And so this brings me to the third aspect, which is what is the role of the state? We also think something we must think about. What is the responsibility? Talked about obviously industrial responsibility and so on. But if we are paying taxes, will we deserve a state or multiple governments at the regional and the federal level that is investing some of those taxes back into combating the kind of harms that we are all experiencing online, whether they're related to financial fraud or behavioral imbalances that result from online interactions, or something more mischievous than that, including information warfare by adversarial countries on all of us. So what are the ways in which the state is capacitating us as users to deal with that? Are there, for instance, in Tamil Nadu today, more mental health referral helpline services, etc., as a result of this legislation that we talked about, or proposed legislation in other states, and so on and so forth? Has the state capacitated institutions to help us reach out and feel a little more empowered in our online interactions? And if not, I believe that the low-hanging fruit, that the states keep taking, the governments keep taking, they're very tempting to pick. From a public policy standpoint, it is incumbent on all of us to first frame it from a larger 40,000 feet perspective and see how different stakeholders are interacting and what roles and responsibility should be. Because regulating in isolation of all of that will always lead to unintended outcomes that we can all foresee, including, like I said, channeling of activities in ungoverned spaces. This is a big problem comes from banning of activities online or offline.
Thank you, Vivan. So now I'll open the floor for the Q&A session. So first,
So, good afternoon, everyone. My name is Sulabh, and the question to the panel is: social media and online forums can drive speculation, right? Creating risk for market manipulation. So, how does internet governance influence investor behavior and market dynamics in online trading platform? And what are the implications for regulation and market stability?
Vivan, was this something you wanted to hop on?
I can just say that, look, maybe you read the newspaper today morning, so you're asking this question, which is good. That's the first step to be more enlightened in tech policy, because the SEBI has just enacted a set of actions to curb speculation in futures and options markets in India. I don't think there's some specific action beyond the market integrity and sort of the regulations on market intermediaries that are required in terms of governing financial markets that relate to the digital sphere. I think there's a big, obviously there are issues around advertisements, on false advertisements, also product placements and influencers giving you wrong advice, and this will also spill over into some bits of AI that we discussed. These are very difficult areas to contend with black and white rules. I mean, SEBI has tried to create some sort of a white list of influencers who can give financial advice. But what if you really like me and you heard everything that I say, and if you have 100 minutes of what I have to say once a week, and out of those 100 minutes, maybe in 30 seconds, I also discuss something that is akin to financial advice. Will you consider me an influencer for yourself or not? Or is it necessary for me to have thousands and lakhs of followers before I am an influencer for you? And it's not an easy question to answer. So, and in the context of bots and AI and so on and so forth, maybe you somehow landed up in a spiral of online activity that has maybe this one website where there's this one bot that you really like, that you not only get financial advice from, but even life advice from. So how do you regulate dispensation of advice online? It's not an easy question. I think we have to come back to look at how the market itself is governed. Some of the actions, like I said, is taken today, and we'll have to keep taking in the future to make sure that intermediaries in the market, which are the brokers, which are the exchanges, etc., they are doing their part to make sure it's a fair market. And there is, if we embrace the notion that there is some amount of fairness in the market, there is no insider trading, there is platform integrity, and so on and so forth. And we also have to embrace the fact that speculation is part of financial activity. It is not something that we can avoid. It is not something that is necessarily deleterious to the whole notion of the creation of a deep financial market in the country. And we also have to recognize the structural problems from where some amount of unhealthy speculation also stems from in a country like ours, where we are at income levels which are at parity with 2019. We haven't recovered from that post-COVID. So there is this mismatch between aspirations and income in the youth in particular. And that leads you to digital lending platforms that may be predatory, and therefore you take loans for consumption, which is in itself an anathema if you think about sustainable development. Or you maybe go to a speculative platform and start trading news and so on and so forth. So I think there's a structural element, there is a limitation to how much you can do with regulation of influencers, etc. And there is very definitive action that you will take at the level of regulated market intermediaries to create some amount of safeguards to ensure it's a fair market.
And if I can just quickly add to that from a macro perspective, this is a question of who regulates what as well, right? Your question was, is there something we can do within the internet governance framework on something like this? The Securities and Exchange Board of India has a detailed set of regulations around who actually is allowed to dispense financial advice. And so that regulation exists. It's a sectoral regulation. It's not necessarily an internet-based regulation, because using the internet to dispense financial advice is using a tool to dispense financial advice. It's a mode of providing that advice. In a similar vein, when you talk about financial payments, you talk about digital payments. There are regulations around what digital payments look like, who can provide a service associated with digital payments, what kind of permissions, etc. are required in order to do that. In spite of that, we see financial fraud, we see financial crime. So this is just more of a long and roundabout way of saying that there's going to be bad actors everywhere in any form of service that's being provided over the internet. One part of the solution is regulation, but it's not a silver bullet. There's a concept in contract and tort law, which is caveat emptor, which is buyer beware. And so as important as regulation is, so is customers themselves, individuals being educated about the do's, the don'ts, financial hygiene, cyber hygiene, just keeping ourselves prepared around those lines. And so I would encourage you to think about regulation not as the whole and soul of the solution, but one part of it which interplays with a wide variety of multiple stakeholders, including very crucially the end customer, the user, the final individual.
Thank you. Next question, please.
Good afternoon, sir. I'm Tarun Kaushik, and my question is: we have been talking in the session about what these policies are, and like how it would be helpful for the citizens. Can you like throw some light on how, on a practical field, would work? Like, let me give you a case situation. Yesterday, the AI officer from Game 24/7 had given a lecture, and he told that he uses our data, the users' data, to predict models and find like the users at what time they play, which locations are they from. Let's suppose I'm a user of of games 24/7, let's suppose. And according to a DPDP Act, let's suppose I quit, the web from the website that I no longer want to be a user, so they have to delete all my data. So how would government make sure that the company adheres to the regulatory framework on a practical basis, not on the theoretical part, which we have been focusing now? So like, how will you make sure my data is completely erased? Because once if AI model is trained, my data is already there. But according to the DPDP Act, it must be deleted, right? So how will you make sure that the company, adheres to the regulatory framework?
See, when data erasure is being talked about, it is the personal aspect of the data which is being erased. Otherwise, for the digital economy to flourish, naturally data analytics plays an important role and will and should continue to play that role. So when a data erasure request therefore has been given to game company A, they need to erase your data, maybe which can be in two forms. One, completely erase certain inputs about you, or maybe erase all the identifiers associated with you and rest continue to use this data as a community data. Second is also not wrong. Second option is also not wrong.
And just on that piece, once your data is used to train a certain model, a model is not trained on individual data. It is trained on bulk. And so the right to deletion of your data extends to you insofar as your profile has been created with a particular online service provider. You say, I no longer want your service, please delete my information. They are required to delete that information, which means from that day onwards, they can no longer use your personally identifiable information to now train their algorithm or train their AI models. And in terms of how would the government make sure that what has been asked to be deleted is actually deleted, businesses under the DPDPA are required to file regular reports, do risk assessments, etc. And so as a part of all of those processes, I think you'll be able to get clarity on what information they have about you and what they don't. And finally, you as a user have the ability at any point in time to go to a particular website, and you're supposed to be able to see what information about me do you have at this point in time, and you should be able to check what information of yours is being used at any point in time by a particular business.
So there is not a regular auditing of the companies by the government?
No.
No.
But there are reports that need to be filed eventually for a certain threshold of businesses.
So,
Yeah.
third,
Good afternoon.
yeah, okay.
Okay, good afternoon, panelists. So, my question is primarily on children's data. So, there's a provision in the DPDPA that certain data fiduciaries will be exempt from provisions if they kind of demonstrate that the manner in which they're processing personal data is verifiably safe. So my question is, firstly, how do fiduciaries demonstrate that their practices are verifiably safe? And Kirti, I understand that you mentioned that it should be principle-based certain legislations, but in this particular instance, don't you think having broad terms such as verifiably safe might run the risk of the threshold being very low?
Thanks. I think that's a really pertinent question. A lot of folks are talking about it today. Whether the term verifiably safe is enough or not, I think is an open question. To your first question, which is how do firms demonstrate verifiably safe? It's open to the rules. The rules will determine what verifiably safe really means. And this is one of the points that kind of speaks to the interplay between legislation and delegated legislation, and how much clarity you can get from a law itself. To my mind, using terms like verifiably safe helps set the regulatory intent and helps set the principle behind what are they trying to achieve. What they're trying to achieve is a safe user experience for children in the online ecosystem. They could have said it needs to be a safe ecosystem, but a safe ecosystem is a much broader term to use. Anybody can stand up and say, yes, my ecosystem is safe. Is it the safest? the jury will always be out, but anyone can stand up and make an argument that my ecosystem is safe. Verifiably safe helps put a certain degree of check and balance on the concept of safety. Is it enough or not? I'm sure there are multiple views on that piece, but I do think that this topic will be more granularly debated in the context of the rules themselves, because how do you operationalize verifiable safety is something that's open for discussion. One part of this was around parental consent. I'm sure you've been reading about how different companies have been having conversations with the government around what is verifiable parental consent, and it leads to many questions around everything from surveillance to choice to just the usage of the internet and the internet ecosystem by children in an accessible manner. And so debates between the government and the business community have reached a point now where everybody admits and agrees that there isn't a one-stop shop solution for verifiable parental consent. The principle is that parents should be involved insofar as children accessing the internet is concerned. Now, for you, that might involve using a particular physical identification document. For somebody else, it might include using third-party service providers that draw signals that help them determine whether somebody is a minor or not. There could be many possible solutions on the table. There isn't a one-size-fits-all solution there. But a lot of these questions, I think, are still sort of a living organism in some way, shape, and form, and are still under discussion. More to come once the rules come out, I would imagine.
Thank you.
Hi. So my question is on future of work. So the work that is outsourced to Global South is now increasingly replaced by AI. That is the work that is done by BPOs and LPOs, which is leading to job insecurity in poor countries. And on the other hand, for example, Amazon's just walkout technology, which allowed customers to bypass traditional checkout, was actually just 1,000 people in India doing the job manually. So how does Global South ensure that it is not at the receiving end of this great AI leap?
Vivant, would you like to answer this?
What is your answer? You are the young generation. I'm sorry, you have an answer in mind before you are asking the question. What is your answer?
Back to Udhar.
I actually don't have an answer.
Do you think this question has an answer then?
I mean, that's up to the panel to answer. I don't know.
No, but I mean, do you feel like this question is one which can be answered definitely? What is the future of work in the Global South?
I mean, it depends upon the policies and the bargaining.
It's okay. Yeah, it's okay. Exactly. So I'm going to give you a depending on type of answer. Depending on whether a large IT services firms that are acting as back offices for OECD customers, depending on whether they can train, upskill their engineering workforces to adapt to a reality where they work alongside AI, are not replaced by people who are working with AI in other jurisdictions. And by the way, a lot of this has happened before AI. So work started moving to Philippines, work started moving to Eastern European countries much before the advent of generative AI in a commercial mainstream context, not because of the technology, but because of language, for instance. Even the Chinese have learned a sufficient degree of English to be able to manage to deal with some outsourced services, which was never thought possible in a world just 20 years before. So it's really a question of enlightened corporate leadership about public policies that incentivize this transition, and about people like you from the bottom up who can see the future if we don't adapt and adopt technologies in a way that our productivity is enhanced and we are not disintermediated altogether.
Thank you, Vivant. Next question.
Yeah. My question is to Vivan. Okay. So my question is to Vivan because he, in his opening statement, Prakash here from OMI Foundation, in his opening statement mentioned the problem related to the protection of gig workers. Now, this problem was initially addressed by the central government through Code on Social Security, but that has not been implemented for 4 years. Now, we see state governments coming up with their own laws that are still to be implemented, and some of them are still to be enacted. Where do you see the policy landscape in this area going towards for both workers and industry?
Yeah, and where I see it going towards is different from what I think it should go towards. So to be clear, I don't think this is the optimal path, but as you've already pointed out, states, there are two or three impulses. One is the impulse to collect greater revenues from formal, mainstream, organized markets. To the extent that the states can impose their will to do so, through, for instance, through the recently notified Senior Workers Act, the long name, you can look it up in Karnataka. There is this, it's a gig economy legislation in many ways because it says that companies are responsible to put aside a share of their revenues towards the welfare of these senior workers. The same thing that you're talking about in the delivery context or the taxi context or whatever you're talking about. The impulse for doing that stems from the state's ability to receive that cess money directly into its coffers, as opposed to rely on the transmission mechanism between the center and the states for GST. And as you know, a lot of GST repayments, not just to businesses, but between the center and states are often delayed. So the states are getting increasingly addicted to this notion of cess, because the cess goes directly to them. There is compensatory cess, for instance, now straying away, but there is compensatory cess, for instance, on sugary carbonated drinks today in the country. It's just because I talked about this topic 3 days ago, I can tell you that cess originates from the construct that, you know, there was a VAT regime before GST. Some states already had an additional cess on sugary drinks like Coca-Cola, Pepsi, etc. And when the GST regime was enacted, they didn't want to lose that additional money that they used to collect on taxation of these drinks. So therefore, a compromise was worked out that there will be an additional 12% tax over and above the 28% GST higher slab that is applicable on these drinks. So that is 40%. So because that 12% flows directly to them, they don't have to wait for the center to respond. So that's one element of it. The revenue addiction, the structural problem with the revenue flow between center and states, until that is resolved, some of these the collateral damage will always be in these spaces that are more mainstream, that are easier to enforce laws within and so on. The second is how you see the future of the bargaining mechanisms play out between digital companies and the new trade unions, so to speak, as well as the old trade unions. So in the context of, say, delivery boys in Maharashtra, there are new trade unions that are affiliated with political parties that are cropping up and that are saying, look, what is this surge pricing equivalent thing that you're doing? You know, why should a delivery boy in Kolaba get more money than a delivery boy in Thane? The market determined answer to that is very clear, but it's not so clear to the delivery boy who is demanding some amount of parity across the state. So the second part of that answer is how will the political economy intersect with these new bargaining conversations that are happening at a state level and levels even below that, at even district levels and so on and so forth. And I think the third part of the conversation is, as I mentioned at the outset, whether we actually see that we can give a higher set of rights to individuals who are part of this digital mainstream, because digital mainstream is naturally going to be more formal than the unorganized, non-mainstream parts of very large sectors that employ lakhs and lakhs of people. And whether it's a state government or whether it's a central government, there will always be a temptation to at least do what you can, even if you can't address the largest problem that I pose, which is how do you bring the informal into a quasi-formal setup across the country, not determined by a sector. The state will always feel the opposite impulse that let's do it at least where we can enforce it. So they will tend to think more like co-ops than economists when they think about the welfare considerations around that question. So I feel it is going to keep heading in this direction. This will be of course, a tussle between companies, states, center, and users.
So, thanks, Vivian.
This
The
is the
last
last question. Yeah, so my question is related to legislative competence since both of the speakers had talked about it. You mentioned how betting and gambling is falling under the state purview, but that's not like the complete picture, right? So if you read the recent 3 judgments which have come on the online gaming, all 3 judgments have struck down parts of that bill claiming that gaming like poker and rummy are not under the legislative competence of the state government because they relied on a Supreme Court judgment 96. So we are in a very peculiar situation where we need a central legislation on games like rummy and poker, even though they involve the concept of betting, which is technically a state subject, and at the same time we need a state legislation for similar games which does not involve skill. So I have very 2 short questions. First, do you believe that multiple legislation on the same subject will increase the compliance burden and have an adverse effect on the gaming industry in general? And second, do you believe that a centralized legislation on this can be made which does not impede upon the concept of federalism?
Actually can be better handled through center, for which it actually calls, or it may actually call for sort of a constitutional amendment, which in any case can solve the problem, but that's a bigger political issue. Duality, in my own opinion, if it is not working today, it will further complex the scenario tomorrow.
And the reason that duality even exists today is because historically there has been a conflation of the concepts of gambling and gaming. They're 2 completely different concepts. But this is an example of what happens when there is a regulatory vacuum at any given point in time, right? As a result of said regulatory vacuum, there was essentially overreach within certain states where the 2 concepts were kind of muddled up into one another. So that duality should ideally not exist. And will an overlap create enforcement issues, and will it be problematic? 100%. Should an overlap exist? Absolutely not. Does one exist today? The answer is yes, and it's something that needs to be solved for.
Thank you. Vivian, would you like to say? Vivian?
No, I think the answer is sufficient. I
Yeah.
just would caution the audience from conflating issues of center and state when it comes to digital, because digital does not exist in the constitution. So while other conversation we need to have about a constitutional amendment, which will take a lot of political will, but it's certainly needed to clarify the role of center and state, and it is not nowhere written that it is within the purview of the states to look at online gambling and betting, even if though it is within their purview to look at gambling and betting.
Thank you. So with this, we come to the end of this very vibrant session, interactive. I applaud the 3 panelists